mind you. But that's nirvana in a contract. So the more things you can identify and define and make particularly set forth, the better a contract it is, for the obvious reason there's nothing to fight about. If you fight about everything before you sign it, there's not much to fight about after, right? So you'll see in these real, what I call real commercial contracts, like bigger deals, shopping plazas, buildings, what you'll see is you'll see all sorts of definitions and additional boilerplate. It's there, it's very important, but the purpose of it is not just to make the lawyers feel like they're really smart or so they can bill more hours, though, you know, that is actually kind of the purpose too, joke. It's so that you don't spend even more money fighting about it later. I will say any money you spend on an attorney to properly draft a contract is probably 100 times literally cheaper than having an improper contract to fight about in court, right? So you're investing in not having to fight later, okay? Interestingly, by the way, in like Europe and some other countries over there, and in a lot of other parts of the world, the court is very simple. Litigation is much more truncated and simplified than we have, but getting into the contract oftentimes will require government consent. Even in free countries, like you'll have to go to a notary, which is very different than a notary here. It's actually like our quasi-judicial person who will review it and have to sign off on it. But then when you go to fight, and so it takes a lot of money to get in, like months to get into a contract like this. But then if you go to fight about it, it's like 3 months and you're done. And it costs very little. So we're in what's called an easy in, hard out system. A lot of the world has a hard in, easy out system. Okay, so when this, if you will, is an effort to make it harder to get into the contract and easier to deal with if there's a problem. Okay, so as you can see, it's just pages of defining things. Now, again, if you review this in your own time, understand that obviously this is a form, which means there's a lot of things that are in brackets, meaning they need to be filled in by the person drafting it. Also, mind you, don't try to use this form yourself, please. There's a lot of stuff that will, like, you know, if I was going to use this, I'd spend literally a day or two almost entirely rewriting it for the deal. Okay, it's literally a starting point. Okay, it talks about the conveyance of the property. It talks about, again, street address, legal description, which, you know, is an exhibit. It includes all building improvements located on the land, all equipment, machinery, apparatus, appliances, articles of personal property, all rights of pertinent, like mineral rights and such, stripped and gores abutting the land, et cetera, et cetera. So like basically everything it's trying to set out very clearly. And it also attaches the leases attached to it, right in the contract. You're going to include the leases. So again, you may be talking about like a high-rise here, like a high-rise office building. Of course, it doesn't include tenant fixtures, etc. Then it talks about excluded property. Now, again, this is complicated, and we're already on what, page 6, and we're still what would be in the first top part of the other contracts, but it's really no different. It's just only different in its level of complexity. It's the same concepts. Okay, it talks about what as is, okay, and in a greater detail. If you notice, it talks about toxic and hazardous materials. It talks about statements and representations that no one's relying on what the other party told them. They're going to do all their inspections themselves. That the seller makes no warranty with respect to hazard or toxic substances above, beneath, or discharged from the property or any adjoining or neighboring properties. Again, back to that environmental stuff, etc. It talks about the purchase price. Okay, it also talks about escrow deposits, but if you notice, again, everything's a lot more complicated. Okay, and then how the balance is paid. And in this case, this is a cash contract, but obviously this is where the financing would go in. Talks about the closing. Now, closings in commercial deals are a lot more complicated than closings in residential deals. Typically, everything's pre-signed over the course of a week or two or even a month with various people, and then someone just kind of puts it all together at the end and FedEx copies to everyone. It's not like you sit at a table or anything like it. It's really like closing by committee. Pretty gnarly, actually, on big properties. You do notice, though, of course, time shall be of the essence. Okay, like I said, you see it in pretty much every contract. And then it talks about deliverables. Okay, now what's interesting, this is a standard form, but if you notice in 402B, it says potentially omitted. And that's just where you're starting with something omitted. And again, the reason being this form itself has changed over time. It's a pretty popular version. It talks about how a special warranty deed is going to be delivered. It talks about a bill of sale, which is really just a deed for the personal property. It talks about how the leases are going to get transferred. And again, just I want to be clear, like the contents of the individual clauses will not be on the test. Every contract's different. So I don't expect you to memorize that. What I do expect is that, if you look at a general concept, you understand the concept, the time is of the essence or legal description or whatever. It also talks about assignments, counterparts, and what a counterpart is if two people or multiple people sign a contract and they sign different copies of an identical thing, it's all considered one document. That's what a counterpart signing is. Tenant notices, you name it, and it goes down to like all the different things the seller has to deliver. Okay, and often this will be greatly expanded. Talks about everything the purchaser has to deliver at closing. Okay, which is obviously all less. Talks about how the closing costs will be paid. Okay, so who pays the documentary stamps, who pays the commissions, who pays for recording. And you see, like, again, this is like a hardcore shot, it could be a high rise, for $40 million, but it really is not that different from even a residential contract. It's dealing with the same basic subject matter. It talks about apportionments. So in other words, how things are split up, if you will, how rent's split up, so even designates a time of day, delinquent rents, collections, etc. Because oftentimes they're being sold like as ongoing businesses. And then what happens to the delinquent rights, whether the seller gets the back rent, whether the buyer gets the back rent, who's responsible for collecting it, et cetera, et cetera. It talks about taxes, which, property taxes, which can be immense on a property like this, et cetera, et cetera. And just goes on. And again, this is specific to that property. So it could be very little depending on the property or very much. It talks again in detail about title, what is considered good title, what can be accepted, or what like problems are okay if there's a problem there. It talks about zoning issues. And again, you see this like choices here. Stuff like that. As you can see, it goes on. Because this is where a lot of the fighting goes. Like I got a buddy, this is all he does is large commercial properties. And he will fight with the other side on a contract like this, literally full-time for weeks. Now mind you, these are massive, massive properties, but like this is all stuff that gets very, very detailed. Like I'm sure you, like some of you guys work for big developers, you know what I'm talking about. It talks about title and how you get the title searches, what the objection dates are for title, and you're setting up all the fights in advance, if you will. And again, it's reiterating, time is of the essence. It talks about what happens if the seller can't sell it. It talks about reps and warranties. Now, what reps and warranties are is when you buy or sell something of this magnitude, there's got to be a bit of a trust factor, right? Because not everything can be covered. So what the seller and buyer do is they make these representations to each other. Like, I don't know of any gas tanks. Like I'm oversimplifying, obviously. Yes, we're Blackstone, but we do have the authority to sell this property, without shareholder consent, whatever it might be. And these reps and warranties, are typically, if there's going to be litigation after the fact, it's from a broken rep or warranty. Okay, this is where the fighting occurs, and this is where you have to be very careful that everything in these sections, the reps and warranty section, is dead on. Okay, huge. This is where the fighting comes. And because again, if you say there's no lawsuits and you forgot that the lady in Oklahoma who was a tenant 3 times ago who got cancer from the asbestos in your ceiling tiles, that suit's been pending for 14 years in Oklahoma federal court, and you don't warranty it, and now the buyer gets dragged into it, they're going to sue you for indemnification and damages. So reps and warranties, very, very important. Leases, maintenance, repairs. Again, right back to that risk of loss, super important. Talks about notices, how notices are made, and usually it's like 6 different people by FedEx, and fax, etc. Very important here, because again, if like you have until 11:59 to cancel, and it says you have to fax it to these 5 numbers and fax it to 4 numbers, you didn't cancel, right? Talks about remedies. What happens if the purchaser defaults? What happens if the seller defaults? Again, sounds familiar, right? Talks about escrow, the escrow agent's responsibilities, how they're holding the money, what happens if there's default. And again, same concept, a lot more detail. Talks about confidentiality. This is something you don't typically see in other contracts. When you're trying to buy a big building like that, let's say, it's generally they're going to want full confidentiality on both sides, because a lot of information is being turned over about business processes, financial concerns. Often these are publicly traded companies. So non-disclosure and confidentiality provisions are another thing you see a lot of fights over before the information is released. Very, very important. You notice the provision survives closing or cancellation of the contract, and a lot of litigation on the financial disclosures like that. Talks about how brokers get compensated. Okay, merger, no representation. So it just basically says everything we spoke about breaches in the contract. And whatnot. Again, no recording of the contract should sound familiar. How business days are computed. Modifications and amendments must be in writing. It also contains, and this may be in the other contracts this year as well, something called the Severability Clause. And basically, it's what we call a savings clause. And what happens is, if you go to court over this contract, and the judge finds that, hey, 1410, whatever, is an illegal clause, without 1409, where it says severability, that clause, the whole contract's bad. But this clause says that if a judge finds a part of the contract's bad, the rest of it's still binding. Okay, so this is a pretty important. You'll see it in almost every contract. Like I said, it's boilerplate, but it's important. Okay, further assurances are just that as you're going through, if the problem comes up or it looks like you're going to breach, the other says, hey, are you going to breach? You got to go, no, I'm not. I'm still going forward. Stuff like that. Again, 3rd time in one contract, time is of the essence. And look how specific it is. Such action must be completed by a certain time, Eastern time, on such date, provided, et cetera, et cetera. Very important. I mean, litigation over time is everything. 1 minute, and you might have a giant lawsuit. Stuff like that. And then he talks about signature pages and all sorts of exhibits. So I know when we spend so much time on the residential, you didn't think we'd get through these other big contracts. But as you can see, and really the reason I did it that way is because even when you're buying that $50,000 condo, it's the same concepts all the way through to the commercial real estate. Dirt is dirt, if you will. The law carries through. What happens is that the complexity gets turned way up, to 11, right? And the bigger the property, the more complex it gets. But at the end of the day, the concepts are identical. They're really the same ideas, with a few exceptions, like the residential disclosure versus commercial disclosure, that sort of thing. That's it for the class. Let me just double check before I let you all go. I know we're out of time. I just don't want to miss anything. I do want to remind you again that week 5 and week 4 got swapped. Oh, another thing I wanted to remind you, I'm glad I remembered. Office hours, questions. I'm really good with email, and I've even been checking the Canvas thing every day. You can email me at the school email. I'm having it forwarded to my work account, so I'll see it. If I don't respond to you within 1 day, like by the next day, hit me again, please. It means that I didn't get it, because I will always respond within a day. Just about always respond within a day or so. So it's not rude to hey, did you get my last email? I get 500 or 600 emails a day. It's so easy to hit delete and 2 things get deleted. You know what I mean? So please email. If you want to talk to me, office hours, even if it's just to talk about something we went over in class that you didn't fully get, call my office, Just tell anyone who answers that you're my student, and they will set up a time for a callback. I will then call you back at the number within 15 minutes of that time. Okay, and the reason I say within 15 minutes is because I group them, and if someone else goes over, I may call you back 5 minutes after 4:30 or whatever. So like within 15 minutes, try to be on time, but give me 15 minutes extra. And it's the easiest way. That way you're not sitting there waiting for me to call you back or trying to fit in office hours. Just ping me an email or call my office. They'll set up an appointment, and I'll just call you back and go over whatever you want to go over happily, or answer your questions via email. I should have said that earlier. Any questions in our last 60 seconds?
Professor Singer, when is the video going to be posted? I mean, I was taking notes.
Class, I'm gonna let you guys out early by 25 seconds. Oh, thank you very much. I know I fire hosed you. It will not be like this every session. We're going to go slow down and go into detail with all of this now for the rest of the class. So don't worry about that. It was kind of on purpose just to give you familiarity. And we'll talk to you soon. Have a great week. I'll see you next Saturday. Thank you so much. It's a pleasure to meet you all.
Professor, someone asked a question I think that if this video will be recorded to refer back to taking notes.
And here we go.
Can he hear me?